Good morning, good afternoon, everybody that is joining us for this webinar on Pluriland to talk about our new project, our new collaborative project here based at LawTransform. And we're delighted to be able to have the chance to present some of what we're going to be doing over the next 4 years in this project with all of you here at the Bergen Exchanges. My name's Rachel Cedar. I'm going to be chairing the webinar and I'm one of the coordinators of the project over the next 4 years. So what I'm going to do before I introduce our panelists one by one is just present to you very briefly an overview of 5 minutes of the project itself. So if I can share my screen and come up with my PowerPoint. Oops, sorry. There. Okay, I will just talk us through it for 5 minutes briefly before we hand over to our different panelists who will be talking about some of the country cases, not all of the country cases we'll be presenting today in the webinar. But the title of the project is Pluriland, Theorizing Conflict and Contestation in Plural Rights Regimes. Here at LawTransform, we've brought together a really exciting group of researchers, many of whom, as you will hear from them, have been working on issues of land for many years and of rights of different marginalized groups, indigenous peoples, Afro-descendant groups in Latin America, and others. So we will hear about that. But I guess what has brought us all together over the years through LawTransform and the Bergen Exchanges and at the Christian Michelsen Institute in Bergen is that we're all working on issues of socio-legal mobilization and trying to work out how law matters in these rights mobilizations. The project itself, the kind of main problem or challenge of the Plurilands is to try and explain the potentialities for marginalized groups of legal mobilization under different land regimes, different legal arrangements around land in situations of complex legal pluralism. As anybody who works on socio-legal mobilization knows, claims are made at many different scales, levels, institutions, and we're interested in looking at that comparatively, cross-regionally, and what we're hoping will come through this comparative work will be a collective theory building exercise that's going to allow us to say something more about the relationships between these legally plural constellations of norms and sites that govern land ownership, but also access to land and use of land on the one hand, and the processes of socio-legal mobilization on the other. So those are constants in all of the case studies, as you will see, and we're aiming to be able to say more than just the sum of the parts with the project itself. And what we are aiming to do then is to build a comparative multi-factor typology, which will focus on these 3 things. The kinds of threats to existing land regimes, or the kinds of threats that marginalized groups that have protective clauses in or arrangements on the books, at least, are facing. And then the second 2 aspects, which perhaps are the more predominant in the cases, as you'll hear, are the types of framings that different groups are using to pursue land claims, and the legal sites. So where are they actually being disputed? And the cases that we're going to be looking at, we'll hear about 4 of them today, which are South Africa, Colombia, Ethiopia, and India. But we're also going to be looking at Brazil and Guatemala as case studies for the project itself. What we're finally also interested in, what are the intragroup effects of these processes of legal claiming, particularly how do they impact on gender relations and on interethnic or racial dynamics within the groups that are claiming either successfully or unsuccessfully access to ownership of land. Okay, I'm going to stop there and hand over to our first speaker, who is Jackie Dugard, who is a lawyer and researcher, socio-legal researcher from Wits University in South Africa. And Jackie will, what we're going to do is have a first round of about 10 minutes of intervention from each of our panelists. I'll introduce them as they come onto the screen. And the first round is asking them essentially, what are you planning to do as your case study? And then we'll take a second round, slightly shorter, where we'll ask everybody how they're planning to do it. So the second round will concentrate more on methods. Okay, I will then, hand the floor over to Jackie, but I am going to put a PowerPoint up for her first. But Jackie, do you want to?
Yes, thank you. Thank you very much. And hello to everybody in Bergen and around the world that's joining this webinar. So as everybody probably is aware, South Africa has a recent past of political struggle against white minority rule. And the legal and socioeconomic consequences of this play out very much on the context of land. So, for example, one of the key features of apartheid was widespread disposition of land. I should also say that that has a precursor in terms of colonial disposition, and some people don't distinguish between the colonial and the apartheid dispossession and just call it colonial apartheid dispossession. So if I could have the first slide, please, Rachel. Thanks. So the recent past in South Africa is obviously wide-scale colonial and settler colonial apartheid dispossession, which resulted in the minority white population owning about 80% of the land, and the majority black population pushed into small rural areas that were called Bantustan's homelands, which were ethnically allocated to people according to their quote-unquote ethnic group. And other black people who were the few that were allowed to live in urban areas had very limited tenure, and in any event, eviction was available always to a landowner. And obviously one of the big features of this, Rachel, I would just have to go back, I think. Yeah, thank you. So one of the features of this was that, as with many countries, prior to colonialism, there was not land ownership per se, and that land was held collectively in terms of customary land law. There were rules around use and occupation, but not ownership. And obviously the colonial legal apparatus, which was then pursued under apartheid, was very much an ownership paradigm, but only really for white people. Black people were for the most part excluded from land or property ownership, particularly land. So these two systems developed alongside each other, and actually with very little interplay between them because of apartheid separating spatially black people and white people. So there was widespread dispossession and widespread tenure insecurity, and eviction was a big tool of the apartheid regime, which allowed white landowners in the service of the apartheid system to systemically dispossess people from their land and to evict them. Obviously, there was a negotiated settlement after decades of armed struggle in South Africa, and there was a negotiated settlement in 1994. During this time, in the run-up to the negotiated settlement, land was a major issue. So for Black people in South Africa, land has always been a key issue, and this is something that Rachel has mentioned, and I'm sure everybody in the project will mention, is that beyond its economic value, land obviously has huge social, cultural, and identity-related values. And so land has always been an extremely emotive issue in South Africa, particularly given the dispossession. So Section 25 of our final, we call it our final constitution, but of course one never knows. But that constitution is from 1996, is the so-called property clause. And it represents a compromise in terms of which the haves, mainly white people who owned land, were protected against arbitrary deprivation of their land. However, it provides a lot of mechanisms and scope for widespread radical transformation of property and land, in that expropriation is allowed in the public interest. At the moment, there is some debate about whether it would have to be with some compensation. I've always argued that the way it's formulated, probably there wouldn't necessarily have to be any compensation per se, but that's a political debate right now in South Africa about whether to change the constitution to allow expropriation without compensation. There is also clauses on redistribution of land, on restitution of land, and on tenure reform. In addition, plural land use and occupation arrangements are recognized, and there is significant protection of land tenure of use and occupation against arbitrary eviction. Finally, a very important feature is that a land claims court was set up as part of the post-apartheid institutional machinery, and the land claims court has a specific role. It's a very precise, specialized court, obviously dealing with land issues, and it has jurisdiction over the 3 acts that I will talk about now. Next slide, please, Rachel. Thank you. So what I would like to do in this project is to look at 3 fault lines that relate to land conflicts and land issues, clashes in South Africa. So the first has to do with restitution. So the idea behind restitution is to return dispossessed land to people who were dispossessed. Now, I say return because that land, and by the way, just to make the point that we don't actually in South Africa go as far back as colonialism, largely for practical reasons. So it's essentially dated from 1913, which is when a land act, a Natives Land Act, was passed. So from that date, if you were dispossessed after that date, and you can prove the other factors, then you could have claimed for restitution of land. What I'm trying to get to is that you probably yourself were not dispossessed of that land because it probably occurred before you were born or when you were a small child. So this is about really restitution to the descendants of people who were dispossessed. But the idea is to return the land to the communities that were dispossessed. And that return can come in a number of forms. It's recognized that one of the conundrums is, of course, that hardly any Black people who were dispossessed owned the land outright. It actually probably was only so-called Indians or coloreds who had individual ownership, largely in Cape Town, where that was allowed in urban areas. So there, the dispossession would be remedied by individual ownership return of the land. But for the majority of Black people who lived under communal land tenure arrangements, they would either get the land back under communal land tenure, in other words, customary land law, or they would get it back. A new vehicle was created for that customary, communal property association. So it's a legislative vehicle, and there's a law governing it about creating a communal property association. So restitution is governed by sections 25(2) to 9 of the Constitution that create the imperative for restitution. And then there is a Restitution of Land Rights Act of 1994, which sets out the parameters and also establishes the land claims court. Importantly, you need to have been a person or community dispossessed of property pursuant to racially discriminatory laws or practices. and then you are entitled to restitution or equitable redress. So that's the first fault line. The second fault line, Rachel, if you could move to the next, thanks. So labor tenants. So this is a situation of people who have been it's a practice I think that's common in many parts of the world, and certainly in the past was common, where you would, in return for living on a piece of land, you would give your labor to the landlord. So you would live on the landlord's land and you would give your labor. And labor tenants had very insecure tenure under apartheid. So the Labor Tenants Act of 1996 seeks to remedy this, and it also is pursuant to Section 25(6) of the Constitution, and that would attempt to provide labor tenants with a mechanism to actually apply to own the piece of land that they had been working for those years. So that's the second fault line. So that's a clash between the tenant, the labor tenant, and the owner. Next slide, please, Rachel. Then farm occupiers. So here you have people who've lived on rural areas, and they often do bit jobs. So they'll do seasonal sharecropping for the owner. They might work in the kitchen or the house of the owner. And they had also very insecure land tenure and were often evicted. So the Extension of Security of Tenure Act of 1997 sought to remedy this by protecting them against arbitrary eviction. So here you have a clash between farm dwellers and the farm owners. Next slide, please, Rachel. So, actually, in fact, this I can leave to the methodology. So let me just go into this a little bit more. So in these three sites, what I would basically do is to look at the clashes between the status quo and the power holders, and the attempt to transform those sites. So in the restitution, what you would have is a situation of a current landowner who has had the land probably almost always white, and being pitted against a Black community or group or even individual who was dispossessed historically. So you have that clash, and you may have a clash of ownership versus individual ownership versus communal land tenure. So that is that site that I'm interested in. In the farm dwellers, I'm interested in the clash between ownership and use or occupation. So those two paradigms. And again, it's usually racialized. It's usually a white landowner versus Black farm dwellers. And in the third site, relating to labor tenants, the issue would be the owner of the land versus the labor tenant seeking to get a piece and own it of the owner's land. All of these things in South Africa very much engage the state, because the state in our post-apartheid arrangements is the custodian of land and is also meant to be the driver of land reform. And that's very clearly a mandate in the Constitution in Section 25. So in all of these instances, you've also got a question of what the state's interests are and also state implementation. Unfortunately, in South Africa, state implementation of land reform has been extremely remiss. So that's one of the features and one of the threats that arises across both of these, all three of these sites. But I'll leave it there, and we'll discuss more in the methodology portion of our seminar.
Great. Thank you very much, Jackie, for that. That's wonderful. I'm trying to put my video back on, but not managing. But even without the video, I'm delighted to introduce our next speaker and our next case study, which will be Colombia, and we're joined from Mexico City by Tatiana Alfonso, who is a researcher and a lecturer at the ITAM here in Mexico City. And Tatiana's going to be working on this case together with Elena Alviar, a colleague who is at Sciences Po in France. But I'm going to open up now. Tatiana, thank you.
Thank you, Rachel, and thank you all for being here. I'm really glad that we can have this webinar and just get to present some of the ideas that we're pursuing with this project. So I'm going to present the case of Colombia. I'm gonna share my presentation. that we are working on with Elena Albiar, as Rachel just said. So I'm gonna start presenting a little bit of the context of Colombia and why Colombia is an important case for the project, and trying to understand how conflict and contestation around land rights occurs in the country. So following the research questions that Rachel already presented, I just want to start by saying that Colombia's landscape, let's see, I don't know, can you see the presentation?
Yes, we can see the presentation. I'm just wondering if you can make it full screen.
Yeah.
Down at the bottom somewhere. Don't worry.
Yeah, now it should be there.
Okay.
Is it there?
It's there, but not. Yes, that's perfect. Thank you.
Okay. Sorry. Well, in general, like we're going to analyze Colombia, starting by the fact that, as many of you probably know, Colombia is one of the countries in which land conflict is in the center of social and political conflict, as well as in all the legal disputes about land rights. So Colombia is one of the countries in Latin America in which we've had an ongoing conflict for more than a century. It depends on who you ask to, right? But for so many years, and land is one of the drivers of that conflict. So it is important to know that Colombia's lands rights and situation is very, very marked by really important disputes between different actors that want to have access to the land, and that with the historical course of political events in Colombia, they have pushed for different types of land regimes. So what we see in Colombia is that we still have a country in which 84%, a little bit more of 84% municipalities are considered rural. So it's a huge part of the territory, and about 30% of the population live in rural areas. And this index is lower now because of the forced displacement that has been caused by the armed conflict. So we have seen a country that's increasingly going to the cities, like the population, but still very rural. And the most important elements of the conflict happen in those rural areas around land tenure and land rights. So we have seen, and we've had decades of disorganization and high levels of informal tenure in Colombia, which means that we have like a really complicated social conflict around property, tenure, and land use between different types of actors that we would expect. So this is an image of the rural index of Colombia. So what you see, the parts with the dark green spaces are the most rural municipalities, and the light green are the other ones that are in the indicator of the middle when you consider the rural index. So you can see that it's a huge part of the country, and as you can imagine, those dark green areas are mostly populated by indigenous peoples and Afro-descendant communities, just because of the historical trajectories of exclusion and structural inequalities. Those areas are far away from the center, which means that the state didn't pay attention to them for so many years. And despite that situation, of course, those are the areas in which people are facing some of the most complicated expressions of violence in the middle of the armed conflict, and also several different threats to land rights and land tenure. So with that landscape, what we have seen in Colombia is that with that disorganization and high levels of informality for so many years, we have also witnessed a gradual emergence of diverse land regimes in different moments and with different narratives and frames. which also has meant that we have seen an increase in the threats to land tenure and rights. So at the end, what you have is the same land, but several claims and a diversity of claims, which ends up with a landscape of different and overlapping land regimes, which I'm going to explain like schematically, and then I'm going to show you an image just to have, like, for you to have an example and an expression of how this goes. So in general, we can say that in Colombia we have well, different threats to existing land regimes that comes from the state recognition of land regimes and identities that claim different types of rights over land. And then we also have extractive projects, which means, which triggers different social conflicts over land claims. And we can see competing frames all the time between property rights, a property rights frame, and then the frame for land reform. And then at the end of the 80s and the beginning of the 90s, we saw all the multicultural frames coming into our constitution. And then it came with a huge and important recognition of land rights for ethnic groups, mostly indigenous peoples and Afro-descendant communities. And finally, in the last decade or so, we have seen the emergence and a strong presence of the transitional justice and restitution frame. That means that we have different competing frames and also legal sites for competition and conflict about land. At the end, then we can identify at least 3 different types of land regimes that are competing over land, and means that also you have different types of populations competing for those land rights. In the first place, we have like a more traditional land regime, which consists in land allocation and formalization for peasants, basically, which is the traditional frame that came from land reforms in the 60s and the past century in the 60s in Latin America. But in Colombia, land reform failed rampantly. So that you still have, of course, all those claims that ask the state to allocate and formalize land and property. So in that frame, you have a political process that claiming allocation and formalization is designed for peasants and the identity of peasants, and end up in the recognition of individual tenure or individual property, it depends. Then you have a second huge land regime that emerged in Colombia with the Constitution of 1991, which is requires from the people to claim an ethnic identity, basically indigenous identity or Afro-descendant identity, and that's tied to the multicultural reform process that we had in the Constitution in 1991. And that land regime ends up in the recognition of what in Colombia is called collective property, but we will see it's just collective tenure. It doesn't have all the features of property, but it's collective for the community, and it's based on ethnic recognition and the idea and values of cultural difference, not so much in structural inequality as those groups have suffered. And then finally, we have the more recent land regime, which is the land restitution regime, which is tied to the political process that emerged from the different transitional processes linked to the armed conflict in Colombia. And then it is associated with a new identity in rural mobilization in Colombia, which is the identity of displaced victims of the armed conflict. That, of course, you will see so many people that are indigenous or Afro-descendant, as well as peasants that are also displaced by the conflict. And this regime ends up or is summed up in individual or collective property. So what it means in Colombia is that you have, this is a basic map of, I'm just gonna give you an example of one municipality in Colombia, so you can see what happens with those different plural land regimes. So this is the map of Colombia, and in red you're seeing the Cauca, which is one of the administrative divisions in Colombia. And then within Cauca, this is the map of Caloto. Caloto is the name of the municipality. So I hope you can see the map as big as possible, but I'm just gonna say, like, this is a municipality in which you have indigenous, a huge territory for indigenous peoples, and also you have peasants, and then you have several extractive projects and Black communities or Afro-descendant communities. So what you see in purple is the area of the indigenous territory. What you see in kind of yellow or like light yellow, those are the areas that are designed for the exploitation of minerals. So as you can see, like in the map, it seems that they are divided by clear limits, but of course that's not the case in practice. And there is, in the bottom part of the map, a huge overlap between those areas for the exploitation of minerals and the indigenous territory. Also, you see, what you see in the red spots are requests filed by displaced victims of the conflict for land, which has, of course, like different types of overlaps with the other regimes. So in the end, you have, of course, the same land, but fragmented people and fragmented regimes. So we are trying to understand that, and one of the important things, we're trying to understand how conflict develops in that context, and also how land regimes, which means the legal design and the legal rules of the land tenure regimes, but also means economic values that are embedded in those regimes, how triggers different types of social conflicts and claims over land, and what's the state response, right? So in those axes that Rachel mentioned. So in the first place, what we are gonna do is we're gonna build the national landscape of regimes, which means asking and analyzing all the petitions and judicial processes of land allocation, formalization, collective titling, and restitution. So we have a map of the entire situation in the country. And then based on that, we're gonna identify different configurations of localized conflicts and contestations across those three areas of the country in which we know that we have all the plurality playing out. And then we are gonna do 2 subnational comparisons. The first one is between individual claims of restitution and individual claims of allocation, which means that we can compare the state responses to one community that has claimed restitution and one community in the same municipality that has filed a petition for allocation and formalization. So we will understand how the state responds, of course, to different claims of land regimes according to their features, the framing that the community uses, and of course, like the process of mobilization that these communities use to claim the land. And second, we are gonna also have a second subnational comparison between collective claims of ethnic communities that have a formal title versus a collective claim of an ethnic community that does not have a collective title, but both of them are facing the threat of extractive projects. So we can understand how the framing of the land tenure and the land regime works in front of a threat of extractive projects. So we can see if the mobilization process and the framing works, and to what extent in front of that threat of extractivism. So if we have both the national landscape and then these 2 in-depth analyses, we hope to understand how Pluriland actually is working and developing in Colombia, and we can understand and answer those questions about the combination of factors that is giving more traction or not to the claims of marginalized groups in the context of Colombia. So I would leave it there. I guess I'm out of time, right?
Wonderful. Thank you so much, Tatiana, for that. That's great. We now will move to our third case, and I'm delighted to introduce Mekonnen Faru, who's going to be working on Ethiopia as part of Pluriland, and Mekonnen's joining us from the University of Missouri. So Mekonnen, the floor is yours. Thank you.
Thank you, Rachel, and everyone. I was trying to share my slides actually, but apparently cannot. Is there Anjame?
Let's see if we can try and work out that you can share your slides. Anja, could you help with that? Okay, maybe you could send us the slides, Mekonnen, on an email.
Okay.
That would be great. Sorry, everyone. We're just trying to get a technical glitch sorted out with the slides. Did you send it to me, Mekonnen?
I have just sent it.
Okay. No, I haven't got it yet. I tell you what we're going to do, while Anja and you sort out the slides, I think maybe we'll move to India and take Namita and then come back to you, Mekonnen, if that's okay. And that'll give us a little time just to sort out the presentation. Thanks. We'll come back to Ethiopia in a moment, but for now, the fourth case study we're presenting today is Namita Wahi from CPR in New Delhi, and Namita's going to be working on the India case for Pluriland. So over to you, Namita. You need to unmute your microphone.
Yes. Thank you, Rachel. Good evening, everyone. It is a great pleasure and privilege to be part of this project and this webinar. And I want to start by thanking Siri and the team at the Center for Law and Social Transformation for organizing the wonderful Bergen exchanges that I am really privileged to participate in every year. And I also want to thank Rachel for coordinating this project and for chairing this webinar, and all my colleagues who are going to be part of this project. I am working on the India case study for this project, and there are many similarities in the stories that have sort of come out about South Africa and Colombia, and many dissimilarities as well. And I think the strength of this project is really to explore comparatively the similarities in the stories of plural land regimes across these countries. So to give you a little bit of a background on India, with the population of almost 1.3 billion people, India is not just a country; it's a continent, and so no wonder we have plural land regimes in India. One would not expect differently when land itself is so diverse geographically, from mountains to deserts to forests to the oceans, to plain lands to agricultural lands, and so on. So land is geographically very diverse, and we also have a history of colonialism. But unlike South Africa, this was not settler colonialism. In India, colonialism was by conquest. And it didn't happen all at once. It happened over a period of 200 years. So India was colonized gradually, and it was also decolonized gradually. Starting from as India was colonized, so the land regimes were established by the British colonial state. And so the first part of India that gets colonized is in the east with the Bengal, what becomes later the Bengal presidency. And the purposes for which land laws were enacted during the colonial period were to maximize revenue for the British Crown. And so we see a focus on creating legal arrangements that will enable the government to extract as much revenue as it can from the land. So there's a lot of focus on agriculture, on agricultural land, on settling people on land, and the laws are framed accordingly. However, there is a lot of resistance also. So the story of land regimes in India is one of dispossession, but also resistance. And so we find that the resistance happens both through dialogue, but mostly through armed rebellion and conflict, because the people who are dispossessed, particularly by the British colonial state, have really no say in the process. And so this happens, the British state basically organizes land into two types of land. There's the revenue lands that have agricultural activity and can yield revenue, and the forest lands. Forests are lands which also provide a source of extraction for minerals and forest produce and timber. The regimes relating to forest land are different from the regimes relating to agricultural land, and that pretty much characterizes much of the laws of the British during the colonial period. But of course, there is continuous resistance. So, in the beginning, the British create land regimes that create landlords called zamindars, where a zamindar literally means a holder of land. And we have this zamindari system, dispossessing or derecognizing the rights of tenants and sharecroppers. Similarly, in the forests, the British state creates these very draconian forest laws, which basically derecognize whatever rights the communities that were living in the forest possessed. And these communities, known as the Adivasi or scheduled tribes and other forest-dwelling communities, are basically dispossessed of their rights by the forest laws that are passed in the 19th century. Then we come to 1947, India becomes independent. In 1950, we adopt a constitution, which is now 70 years old. And, following the adoption of the constitution, so the decolonization of India already begins to happen in the early 20th century. Some amount of legal and political autonomy is given to certain parts of India through representation or in provincial legislatures. That starts as early as 1937, but not in all parts of India, particularly not in areas where you have the Adivasi or indigenous communities. And once India becomes independent, once the constitution is adopted, this process is accelerated. But many parts of the country continue to have legal and political autonomy in keeping with their sort of joining the Indian Union. So that's the situation where we have pre-existing plural land regimes, over 200 years of colonial rule, and then 70 years of post-colonial rule. We see first in the decades of the 1950s and 60s a focus on land reform. So, the abolition of intermediate land tenures, so the zamindars, so it struck me, Jackie, as you were speaking, that, the debate that is happening in South Africa is very similar to the debate that happened in India in the 1950s with respect to the constitutional property clause. We had a constitutional property clause, the fundamental right to property in the constitution in 1950. And again, there was a lot of pushback against the clause, which allowed for some compensation to landholders, precisely because many believe that zamindari had to be liquidated, that these people's property rights were undeserved, like it is in the case of the perhaps argued in the case of the white the apartheid owners of land, and that leads to the dilution of the fundamental right to property to a point when in 1978 the right is completely abolished. And after that, sort of the discussion of land in the space, in the legal space, sort of goes away. even though land reform is not fully implemented, the legal rights have been diluted for the purposes of land reform, but land reform has not been implemented. On the other hand, because the colonial laws relating to forests continue in the post-colonial period, we see systematic dispossession and eviction of forest-dwelling communities, including Adivasis and scheduled tribes. This then, so the land reform laws, just to sum up, during the colonial period, we have a lot of laws that dispossess many groups with respect to their land rights in favor of the state. And there are a series of, there are laws of expropriation or land acquisition. We had a law from 1894. Then we also have laws relating to forests. And we also have laws relating to mineral extraction, all of which dispossess the communities and the people of their rights. In the post-colonial period, we have some protective legal regimes. There are land reform laws that seek to create rights for tenants and sharecroppers and so on. And then after decades of struggle, we also have something like the Forest Rights Act of 2006, which recognizes the rights of forest-dwelling communities, particularly Adivasis, but also other forest-dwelling communities. So we have these protective legal regimes coexisting with the expropriatory as well as the regimes that actually established greater state power over land rights to the expense of individual and community rights. And land is a very emotive issue in India as well. I mean, it is although many in government and in policy discourse tend to refer to land as a commodity like labor and capital. The blockages to economic development are coming from land as a block. In actual fact, land is not just an economic, it's definitely not a commodity, it is an economic resource, but it is also something from which people and communities derive their social, cultural identity. And their history and their culture is also connected with that. And there's no greater evidence of that than the current pandemic and the lockdown. Because the reason why we are meeting in this online forum is because of the COVID pandemic. But in India, apart from the pandemic, we had which has created an economic and social crisis. We had a man-made crisis created by the lockdown, which was imposed at very short notice and caused an exodus of migrant labor who was moving back to their villages. And of course, one of the primary reasons why migrants were moving back was because the lockdown meant that they could no longer work in the cities for their economic sustenance, but also because of the fear and the stigma that was associated with the pandemic, many people were moving back to their villages at tremendous cost, walking hundreds of miles in the hot weather in India. And how hot it does get in India during the summer. Many lost their lives, primarily because they wanted to go back to that sense of belonging that they have with the land in the villages. And that is the psychological connection and the social and cultural identity and the connection with land that, that is perhaps not there with any other thing that is, that economists like to, commodify. And I think that's the important thing that needs to be recognized, that land is a resource upon which multiple groups can exercise property rights. And that also takes us, to the point of that Rachel, you raised at the beginning about, the gendered claiming of land rights. I mean, recently, the women in India, until 1956, when we have the Hindu code, did not have equal rights to inherit property. And even after that, it has taken 50 odd years. There was a judgment that just came out from the Supreme Court yesterday or a couple of days ago that has further improved the rights of women to access property. But in many states, they still have unequal rights of access to of women to property with respect to agricultural land, and those still exist on the books. So there is a lot of gender disparity in terms of access and ownership of land. So that's the environment in which we are working. There are plural land laws both from the colonial period and from the post-colonial period that encapsulate in the two narratives on land. So there is the state narrative on land, because that was the British colonial state's narrative on land, but those laws were continued in the post-colonial period. So the Indian Forest Act of 1927 still exists. The Land Acquisition Act of 1894 existed until 2013, when it was repealed and replaced by a more progressive law. And what that then means is that there are the sites of contestation. So going back to the questions that you had raised, that what are the threats to existing land regimes? Well, the existing land regimes are in conflict with each other to begin with. And the second question you raised was about the sites of contestation for the project that we are trying to examine. And the sites of contestation are at the level of both the legislature, all three actually, legislature and the executive and the judiciary. So at the level of the legislature, like I said, there are these conflicting laws. The Constitution, even though it outlined a charter of rights for all individuals and also recognized some community rights, it grandfathered colonial laws unless they were struck down by the courts as violative of fundamental rights. So many of these colonial laws that are clearly anti people's rights remain on the books. At the same time, there is significant contestation even against the new protective laws that have been sought to be enacted. So for example, there was decades of contestation on, and just to mention the kind of contestation we have on land, just like Tatiana mentioned in Colombia, similarly in India, land conflict is one of the biggest sources of conflict. By land conflict, I mean both legal conflict, that means cases in courts. I estimate that based on our work at the Land Rights Initiative, that about 25% of all Supreme Court cases that have been decided till now deal with land. And 30% of all land cases actually deal with the state's power of expropriation under the land acquisition laws. So obviously, so a quarter of all decided cases are land cases. There are other studies that estimate that 66% of all civil disputes in the lower courts are with respect to land. So there's a significant amount of legal conflict, but there is also a significant amount of extra legal conflict. So Land Conflict Watch, a group of journalists and people working on the ground, estimates 700 ongoing on-ground conflicts with respect to land. And they also estimate that land conflicts are threatening investments worth $200 billion. So land conflict is very much an important issue, both from the point of view of like the biggest source of conflict in terms of an impediment to India's growth trajectory, but also in terms of articulation of people's rights. And so the sites of contestation tend to be at the level of law. The second site of contestation is at the level of the executive. So even though in 1950 we have a progressive constitution, we have a parliament, and so on. What we do have is the bureaucracy and the executive branch of government pretty much, continues as it was during the colonial period, and so what that means is that even when you pass progressive laws like the Forest Rights Act, the Forest Department, which has a colonial mindset, perhaps is very reluctant to implement these laws. And so even if you pass protective laws, they may not get implemented. And the third site of contestation is the judiciary, where the courts have tended to obviously protect claims that are embodied within law. And that leads to another observation that I'd like to make, which is that what I've found in my research, both on the land acquisition cases as well as on land rights of tribal communities, is that when people are given legal rights recognized by law, they can go to court for enforcement of those rights. But so when they have rights, they can go to the courts. When their rights are not recognized by the law, it leads to on-ground contestation. So these are the three sites of contestation that we're looking at. And I think I'll stop there and continue in the later discussion.
Great. Thank you ever so much, Namita. That's wonderful. And we will come back to India in the questions. I can see people are typing some questions in the Q&A box. So thank you for those. And please, if you have questions for specific participants, do put them in there. And then once we come back, we will have a space at the end, hopefully, for the Q&A. So I think we've got the slides worked out now for Makonnen. So great. I'm glad to hand over to Makonnen Furu, who's going to talk us through the Ethiopia study for Pluriland. Makonnen, thank you.
Thank you, Rachel, and everyone. So my research is about the position or role of law in land rights and land market. So the idea is to show tensions, inherent tensions in the law between policies aimed at promoting land rights and policies aimed at promoting land market. So I have about 8 or 9 slides. I will give you a general idea. These are proposals or questions that I intend to explore during the research for the project. So I will start with the text of the law, text of the Constitution, and the visions about land that has been formulated in 1995. That is a time of transition in Ethiopia from a military dictatorship loosely espousing a communist idea of property, that is a collective ownership of the means of production, to transition to a market-oriented liberal democracy. So the property clause in the Constitution is Article 40, and I will take you through the text of the Constitution. The first clause in the Constitution, the first paragraph, talks about property. So if you take a quick look at the first part, basically defines that every citizen has a right to private ownership of property. And then the second paragraph defines what private property is. So private property is any intangible or tangible product which has value and is produced by labor, creativity, enterprise, capital of an individual citizen. So if you look at the 4 terms, 4 words, labor, creativity, enterprise, or capital, it tells you something about land, which Namita said in an earlier presentation, that land is not a product of any of these variables, labor, creativity, enterprise, capital. So this one gives you actually what the Constitution envisions, what kind of property regime the Constitution envisions concerning land. So if we go to the next slide, you will see an elaborate, sophisticated text about the Constitution's vision of land ownership or land holding or land use. One of the most controversial texts in the Constitution is this sub 3 of Article 40, which basically says the right to ownership of rural land and urban land, as well as of natural resources, is exclusively vested in the state and the people of Ethiopia. It has a complex historical, political, and sociological background that I'm not going to go into at this time, but this is a text which I think is largely misunderstood, as I will show you briefly. And then it says land is a common property of the nations and nationalities of Ethiopia. And the right to land, the Ethiopian peasants and pastoralists have the right to land, the right to use land, and protections against evictions. In discussions, policy discussions about land rights, land use, agricultural development policy, more generally, the sub 4 and the 5, the last 2 items in the Constitution are actually misunderstood and ignored. So people don't actually see that the Constitution provides the right not to be evicted, and the right to have access to land for pastoralists and farmers. And the only requirement is to show that one is a farmer or a pastoralist, and the Constitution automatically sort of grants this protection. And we go to this next slide. There are also market-oriented, development-oriented texts in the Constitution, sort of visions in the Constitution. So what is the market-oriented, property-oriented? Which it says, the government shall ensure the right of private investors to use land on the basis of payment arrangement. Going back to the sub 2, which I have briefly discussed earlier, what that means is land is not a product of one's labor, creativity, enterprise, etc. Therefore, it is not within the realm of private ownership, but private investors have the right to some sort of protection based on payment arrangements. So here, what we see is a sort of regulatory scheme to promote investment at the same time while not granting private rights to land. And then the rest of the provisions talk about how farmers, peasants, or anyone, any citizen have the right to private property on improvements on land, which goes consistently with the definition of private property in the earlier provision, which defines it in terms of creativity, labor, and capital, which doesn't extend to land itself, but one's investment capital or improvements on land. So these are the overall constitutional architecture of property rights in regard to land. So we'll go to the next point, and that is the next slide, and that is an area. Yes, that is a point I want to discuss. So, as I briefly discussed, that the overall constitutional provision is complex, reasonably sophisticated, distinguishing between private property and the arrangements to use land. But in the policy discussions and subordinate laws, that is the statutes issued by parliament and regulatory agencies and etc., there is confusion about what kind of rights or entitlements farmers have over land, and the role of the government in that arrangement, and the power, rights and titles of the private investors. If you look at a typical World Bank, USAID, UK aid agency, or any of the Western donors, and Ethiopian development agencies as well, one of the mantra is that the state owns land. That is not actually accurate, but that is the general understanding. The state owns land, and then from that premise, a number of conclusions follow. First, since the state owns land, it is inefficient. The farmer's tenure is insecure. This policy, the state, because the state owns land, the legal structure in place is not suitable for ecological environmental conservation. It does not encourage land productivity. So overall, the idea that the state is crude, and therefore policies should be adopted to promote land market. So here you see tension between what the Constitution provides and the policy interpretations of the constitutional provisions. If you go to the next slide, this is a text from one of the consulting agencies implementing the land registration program in Ethiopia. And what it basically says is that they are promoting land investment for transformation program, which is basically promoting microfinance, mortgage, rental, etc. So a package of land transfer schemes, policies promoting land market. So we'll quickly go to the next slide. And so that is a policy interpretation by international agencies, domestic agencies, and etc. And what are practically also land market is common. There is a vibrant land market despite the constitutional limit on the sale and transfer of land. Rental arrangement is usually presented as informal, unwritten, as well as recently growing tendency towards formalizing. connection with the primogeniture. And so the overall issue is policy promoting land markets, practically vibrant land market, which is disconnected from the constitutional text, which limits transfers of land. And there are big structural forces pushing land market in practice. What are these big structural forces? First is urbanization, urban expansion, which is increasing land value and promoting land market. Farmers being indebted to fertilizer and select the seeds, which forces them to rent out or sell their land. Large-scale land acquisitions promoted by government and transnational companies. Speculation, which is the product in part of this, what I call giant forces, and some sort of local nativism along ethnic lines, which also encourages some sort of transactions. But the countervailing force or a negative force against that is agricultural land productivity is still stagnant, nearly non-existent, say since the last 20 years. So we'll go to the next slide. This is the question, actually, the site that I'm looking at. So the constitutional text providing that restrictions on land transfers and land markets, sort of protecting land rights. Policy interpretations, subordinate legislative interpretations provide encouraging or promoting land markets, and practical forces, large-scale land acquisitions, demographic pressure, etc., also promoting land markets. And then disputes arising within that. How do courts and administrative agencies respond to that sort of disputes? And that is a question basically I'm trying to look at. And from the preliminary evidence I have, trial and appellate courts avoid the question of illegality. They look at the expressed objectives in terms of the arrangement, and they usually enforce land transfers. As you may remember from the earlier discussion, according to the Constitution, the sale and transfer of land is illegal. Practically, and in terms of policy, the sale and the transfer of land is encouraged and promoted. Trial and appellate courts go along with that policy and subordinate legislative interpretations, and they enforce the transfer of land. And there are political and ideological underpinnings of this judicial interpretation of the constitutional and the legal text that is promoting land market. And if we go to the next slide, the House of Federation or Constitutional Court, on the other hand, goes along with the constitutional text, which limits the transfer, sale, and the other market transactions of land, looking at the different interpretive mechanisms. That is, instead of looking at the apparent expressed terms of an arrangement, they look at the intentions, the underlying forces creating a transaction or an agreement. So I will give you a simple example. An urban dweller goes to a rural farmer who is desperate with debt to pay debt for fertilizer or seed or because of the rains, etc., and concludes a rental agreement within a limited, legally accepted arrangement. And then the farmer would say, well, this transaction is say for 3 years. Now, the person who rented my land is not giving me back. And the other person would say, well, it was for 3 years, but we had this and that kind of arrangement that it should be actually for 20 years and not 3 years. If this dispute went to the trial and appellate court, they would accept the arguments or the logic of the renter and says this is an acceptable transaction. Whereas if it goes to the constitutional court, the constitutional the Council of Constitutional Inquiry they would say, well, on the text, yes, this arrangement looks like an acceptable transaction, but we understand that actually this is not a legal transaction, because even if the text is 3 years, you are arguing, using different kinds of schemes. It is for 20 years, therefore it is not enforceable. We don't enforce that, it is unconstitutional. So overall, I will be brief. I think I went far above the time allocated to me. There is disconnect between the policy interpretation, the interpretation of trial and appellate courts, and the interpretation of the Constitutional Council and the House of Federation. So on the next round, I will go through the methods. And overall, this is the tension between the interpretation of the constitutional text by different branches of the government or levels of the government is what I'm trying to look at in this project.
That's wonderful. Thank you so much, Makanan. I feel terrible hurrying everybody up, and it's hard kind of sharing and not being actually physically in the same room, but I guess we're all learning how to do this. Okay, those were great presentations from everybody on the case studies, and what we had planned with the 20 minutes that we have left was to have very, very brief interventions from all 4 of the panelists on how they propose to go about doing this research, and to have some time for questions. But I realize that time is going to be quite short, so what I'm going to do is give every panelist 2 minutes to talk about their methodological approach, but also ask you if you could address some of the questions. Some of them are directed specifically for individual presenters, and I'm just going to read them out for the audience here. One from Soma says, thank you for fascinating presentations. And the question is, conflict is about power relations, and how are you framing power issues in your analysis, and are gender issues incorporated? And I think Namita will speak to that. For Tatiana Alfonso, a question from Pradek Nayak about the relevance of the World Bank secure individual land titling or conclusive land titling policy options, and also a question about De Soto's theories of mystery of dead capital as an important policy issue in Colombia, which I think Tatiana will speak to. And then for Makanan, Pradep also has a question there about Hernando de Soto's prescription for land titling and land markets in developing countries, and the extent to which they contradict with livelihood, identity and sustainability issues on land. So those are the questions. There are more questions there, I think, for Makanan from Pradep, but hopefully you can pick some of those up in some of the time we have. But I'd like to move, if I can, to the methodological interventions from everybody. So I'm going to be really strict, and 2 minutes, please. So Jackie, if I can hand over to you, do you want those 2 slides?
Yes, please.
Okay, let me find them. And
great.
Yeah.
Thank you. So what I will be doing, propose to do for the study, is to do a comparison between 2 sites. So these are 2 legal sites, and I will compare all the 3 frames that I previously discussed, restitution, occupation, and acquisition under each of those acts. I will look at cases and compare across 2 sites in terms of the claiming, the framing, and the outcomes of the cases. And the 2 sites for all 3 frames would be the Land Claims Court and then the Appeals Courts, because the Land Claims Court, as I had mentioned, is the court of first instance for those 3 legislative acts. And so people would automatically first take cases to the Land Claims Court. If there is a disagreement around the outcomes, whether by the government or the owner of the land or the applicants, then they can appeal them to the Supreme Court of Appeal and or the Constitutional Court. So what I would be interested in here is looking at whether there are any specific discursive and jurisprudential differences between what happens in the Land Claims Court as a specialized post-apartheid court that was precisely set up to deal with land claims issues. And obviously this has relevance internationally because specialized courts are often set up post-conflict or post in terms of transitional justice arrangements, etc., etc. So looking at what happens in the Land Claims Court versus what happens in the Supreme Court of Appeal and Appeals Court to see whether, Constitutional Court, to see whether there are any differences in terms of the framing, the claiming, and the outcomes. So what I will be specifically focusing on is the question of whether the Land Claims Court can be said to be less or more transformative than the normal appeals courts. And I will use a methodology that has been used before by many in this group, including by Siri Gloppen in terms of a previous project on courts and the poor, about looking at the extent to which the court or the forum rules in favor of the applicants, rules against status quo interests, moves the law forward in terms of the empowering legislation, in terms of its mandate and its objectives. So that's how I'll be deciding whether it's more or less transformative. And so I think that is effectively what I will be doing here. And the first year will involve, so maybe the next slide, please, very quickly. The first year will involve an overview of all of the cases to identify which of the cases have gone to the Land Claims Court and to the Supreme Court of Appeal and or the Constitutional Court. I'm obviously only looking at the 3 frames, so the Labour Tenants Act, the Extension of Security of Tenure Act, and the Restitution of Land Rights Act cases, and then trying to identify whether, I'm not actually sure how many cases yet there will be across each of these 3 frames. If there are too many to do in-depth analysis, then I would have to identify a subset, whether in terms of specific years, specific geographic location, or a sub-theme. And then the question would be to analyze the set of cases or the subset of cases, and hopefully, if possible, if, COVID allowing, etc., and if it's methodologically possible, to ultimately also go and do some direct primary field work with some of the beneficiaries from some of those cases that have been identified. Thank you.
Great, thank you ever so much for that, Jackie. Can I pass to Tatiana, please? Tatiana, to tell us how we're going to go about unraveling this for Colombia.
Yeah, thanks. And you said that you wanted us to answer the questions right now or after?
Maybe after, I mean, to set out the methodological approach, and then, I mean, there are quite a lot of questions there, so for interest of time, I would say just pick the ones that you think are the most relevant and you can answer briefly here. And just to everybody on the participants, I can see some people are raising their hands. Could I just ask you to type your questions into the Q&A box, please, if you've got your hand raised and you haven't done that already. Thanks. Tatiana.
Okay, so I guess I said before that we're going to have like the 2 big steps in the reconstruction of the Colombia as a case study. And the first one is building this national landscape of regimes, which means that we're going to focus on the analysis of administrative and judicial processes of land allocation, formalization, and collective titling and restitution. So we can have a big map of different localized types of conflicts, right? And then we're gonna have the subnational comparisons. So first of all, we are gonna have a historical reconstruction of the emergence of land regimes, because this means that we can map the social and distributional conflict that have given rise to these regimes. And then we can analyze discourse and values that are embedded in those regimes, because as I said, those emerge in different moments of history, and all of them are right now in place. And then so we can also map the actors in dispute and that basically pushed those regimes. And that also comes to this question about the SOTO and the World Bank policies that we'll answer later. So once we do that, we can analyze land regimes in terms of legal design, economic discourses and values that are embedded in those regimes, and then the asymmetrical power relations, because then we can see the type of actors that have been claiming those rights. So this means that methodologically speaking, we're going to have a mixed methods design in which we can collect qualitative information to build a big database that could be quantitative, or that we can have both quantitative analysis and qualitative comparative analysis, which is basically trying to identify different types of configurations, so typological conflicts. So if we can do that, then we can select the specific cases for the in-depth analysis, which means that we will have specific cases for the birth comparisons. And then we can switch to the ethnographic fieldwork if COVID allows us in 1 year or so. And once we get to that stage, the basic idea for the subnational comparisons is that those typological conflicts that we identify allows us to understand specific processes of mobilization, claiming, and contestation for the cases in terms of framing the state responses that communities get, and then specific outcomes for the cases. So outcomes in terms of tenure and land regime, and outcomes in terms of intra-group effects. And we hope we can work on that also using this idea of the transformation that Jackie was talking about. So we can see if there's an impact actually in terms of inequality. So there's this general index of inequality of land tenure and land regimes, but also if we can, in terms of outcomes, inequality means that we can analyze how land regimes, not title only, but the land regime allows these communities to have autonomy in terms of their land. So that's how we are thinking about, the outcomes and the transformation in those cases. And in the second case, we can also analyze the framing process and the mobilization processes of those claims, the state responses, depending on, of course, titles playing here and the role of an independent variable, if you want. But the title is not just the title, but the title comes with different possibilities for the communities to do things with their land. So that grants different levels of autonomy and also different types of grounds for new claims. And also we can compare in those cases the state responses, and then, of course, again, outcomes in terms of tenure and land regime, in terms of dispossession, and then the intra-group effects, because keep in mind that for this comparison, we have ethnic communities that have title, one of them with title and the other one without the title, which gives them different possibilities for mobilization. So the title is kind of framing the structural the structure of opportunity. So that's the role of the title, and then that means that depending on how your claims and your process goes, there might be some backlash on your own process of social organization and social mobilization. And then, so we can have both the database with cases, types of relations, factors that have an impact on the outcomes, and then deep understanding of specific processes of mobilization.
Great. Thank you so much, Tatiana, for that. That's wonderful. I'm going to hurry everybody else up a little bit if I can, because we're really coming close to time. So Namita, can I hand over to you 2 minutes, please?
Yes. Thank you, Rachel. So for this study, I had planned to use a mixed methods approach. Over the past 7 years at the Land Rights Initiative, we've built a lot of data on land laws and judicial decisions. So we have a report we published in 2017, which analyzed all Supreme Court cases on land acquisition over a 66-year period. We had another report which we brought out in 2018, where we basically had mapped the scheduled areas, which are where indigenous communities are dominant. So the first time we created a map of the scheduled areas, both under the 5th schedule and the 6th schedule. We also mapped the forest and mining and other activities in those areas to show that actually there is a concentration of forest and mining activity in these areas. So what I had proposed for the project were two separate paired comparisons. One was on the expropriation law, the land acquisition law. As I mentioned, we had a draconian land acquisition law for a period of 120 years until it was repealed and replaced by a new law, which sought to bring in the people's narrative and give rights not just to title holders, but also tenants and sharecroppers, and make land acquisition difficult in scheduled areas. But that law received significant pushback, and there was a lot of litigation under that law, and that was before the Supreme Court. And there were two competing interpretations of two co-equal benches before the Supreme Court, which just got resolved in April, unfortunately, in favor of the state's interpretation. So the idea at the time I proposed the project was to look at these two competing interpretations and see, how they bring out these two different narratives of the state and the people. The second, so I have to now think about what I'm going to do with that, unless there is going to be a review of that decision, and that again spins us back into the same contestation that has been going on for the past 7 years. The second comparison I proposed to look at was to do not just a law and judicial decisions, but also a key informant interview approach towards understanding the plural land regimes in the states of Jharkhand, which comes under the 5th schedule of the Constitution, and Meghalaya, which comes under the 6th schedule. And the reason why I picked these studies was as follows. So there are 10 states in the 5th schedule, but there are only 2 states where a majority of the land majority of the land of the state comes under the scheduled area. So there are only 2 states. One is Chhattisgarh and the other is Jharkhand. And the reason I picked Jharkhand was because Jharkhand has these particular colonial laws called the Chota Nagpur Tenancy Act and the Santhal Parganas Tenancy Act, which actually, are very distinctive. So not only are the plural land regimes with respect to the 60% of the geographical landmass which comes within the scheduled areas, but it also applies to the almost the whole state of Jharkhand, and therefore creates 2 or 3 different layers of plural land regimes. Jharkhand is also the source of coal and iron ore for the country. Even though it's a mineral resource rich, it is a state, it is an illustration of the resource curse because it is one of the most impoverished states in the country. And so I wanted to look at how these plural land regimes play out with respect to the economic development narrative, as well as the narratives of the people and the state with respect to their land rights. Meghalaya is interesting because of the 4 northeastern states that come within the 6th schedule. It's the only state where the entire landmass is within the 6th schedule. And therefore, they have considerable legal and political autonomy, yet extraction and mining and issues with respect to that are a big issue. Meghalaya is also interesting because it is the only state amongst these states which has a matrilineal system of land inheritance, and which responds to one of the questions that was raised about whether we are looking at gender and power relations within that. So we find even though with a matrilineal system, it remains rather patriarchal in many ways, and the issue of legal and political autonomy means that often tribal elites are hand in glove with government and corporates in dispossessing communities. So that's why this case studies.
Wonderful. Thank you so much, Namita. Sorry for cutting you off, but I want to give the 2 minutes to Makonnen, please, to talk us through how you're planning to do this for Ethiopia. You need to unmute. Great. Thanks.
Okay. So, Anja, if you take me to slide number 7. So in the meantime, so my project will have 2 components in line with the overall project method and the project's framework. Slide number 7. So in the first part, in terms of priority, I'm still working on which one will be first and which one will be second. The first one in terms of work is to actually figure out slide number 7, I think before that. the first one is to look at the mapping out sort of the land transactions and typologies of disputes. What kind of land transactions are there, and what types of disputes and contestations are common. So that is the first part of my work. And that would involve fieldwork, ethnography, as well as the analysis of the constitutional texts and the subordinate legislations. So the point is to answer the type of land disputes, the type of transactions, sort of non-legal economic transactions that give rise to land disputes. And then the second component, I'll look at how courts and administrative agencies respond to claims. And in this component, I will look at sociological factors that determine how and when one decides to go to a court of law instead of settling outside the courtroom, and how the judges in trial and the appellate court and the judges in the Council of Constitutional Court look at different bodies of law in deciding disputes. So just to take a minute into looking at this would be the most important part of my work, because I will look at the structures shaping land rentals. Who gains, who loses, and what are the terms of arrangement underpinning land rentals. From preliminary evidence, there are coercions and unfair terms in land transactions, because on one part it is people who have cash income who actually rent land from farmers, and on the other hand, farmers who rent out land are under conditions of sort of coercion, loosely using that term that forces them into land rentals. So I will look into that. And then the big picture questions about urbanization, indebtedness, large-scale land acquisitions, speculations, and also ethnic political forces that shape land transactions. So that would be the most important and intensive, which requires intensive ethnography. I will look into that too. So it is a combination of analysis of legal texts, judicial decisions, as well as the exploration of practical forces in shaping land transactions.
Wonderful. Thank you so much, Makanan. Thank you to all four of you for your presentations, and thank you also to everybody who's listening to us and who've sent questions in. I'm really sorry if we haven't managed to answer all of your questions, but we're certainly going to take note of them, and we will be thinking about them as we progress with the Pluriland's project. We will have updates on how we're doing on the LawTransform website, and you'll be able to also watch this webinar again, because that will be up on the LawTransform website soon. So thank you everybody very much, and really looking forward to this project and to working with everyone in the coming years. Thank you.